party given the required notice in accordance with the administrative policy of the defendant, and this was properly done by the defendant. Learned counsel also argued that the contract of service between the defendant and the claimant, which is exhibit COJ1, stated the mode of termination by either party given the required notice in accordance with the administrative policy of the defendant, and this was properly done by the defendant. According to counsel, the claimant has alleged reasons for termination to be malice, hatred, and witch hunt by Dr. Onyinye Icho, but those reasons were not contained in the letter of dismissal as the basis for dismissal. Counsel on motives in termination of contract of employment cited the cases of Rivers Vegetable Oil Company Limited and Ibukola, CBN and Abo, NNPC and Obu, Tayo and Kingsway. Just further argued that a claimant seeking declaration that his termination was wrongful must prove certain facts before the court, as stated in the case of UJAM and IMT, Afribank PLC and Osisanya. On the second issue, counsel submitted that the claimant was given fair hearing in accordance with Section 3 of the 1999 Constitution. That the claimant was served with a query, but her answer to the query was found to be unsatisfactory and was referred to a disciplinary committee, while the disciplinary committee performed its role according to the provisions of the administrative policy of the first defendant before the dismissal of the claimant. The claims of the claimant that her dismissal was fraught with malice, high-handedness, and witch hunt go to no issue, as the allegation is based on empty pleaded facts. Counsel further submitted that all pleaded facts and witness depositions of the defendant were not replied to or denied in any way by the claimant. Counsel placed reliance on the case of Alhaji Mohammed Mayaki and Nigerian Deposit Insurance Corporation, that facts not traversed should be taken as admission of facts that require no further proof. So also a submission of counsel that the claimant has failed to show the way and manner the terms and conditions of her service were breached by the defendant, and therefore cannot dump the policy handbook on the court without evidence. Counsel stated that evidence elicited under cross-examination, which was not pleaded, goes to no issue. Counsel relied on the case of Anyafula and Mecca. Counsel contended that in a master-servant relationship, reinstatement cannot be granted, as held in suit number NICN/MKD/04/2016 in Yahaya Adejo Alhaji and Unity Bank PLC, delivered on the 7th of December 2017 by Honorable Justice Lifu. On the issue of damages, it was the counsel's submission that damages flow from natural injuries caused a party, and since the claimant has failed to establish how her employment was wrongfully terminated, then damages cannot be awarded. Counsel finally urged the court to dismiss the entire suit of the claimant. Submission of the claimant. The final written address of the claimant also contains two issues for determination, as submitted by her counsel as follows. Number one, whether in the circumstances of the claimant's case, the purported summary dismissal of the claimant as expressed in exhibit COJ4 is not in breach of exhibit COJ9 and KHMO6 are liable to be set aside by this court. Number two, whether in the circumstances of this case, the claimant is entitled to the reliefs sought. On issue one, learned counsel for the claimant urged the court to hold that in the circumstances of this case, the summary dismissal of the claimant was in breach of the guidelines and policy handbook of the condition of service of the parties. That the procedure to terminate the claimant's employment by dismissal, as laid down under section 8.0, page 3 of exhibit COJ9, was not adhered to by the defendant in dismissing the claimant. According to counsel, the claimant has pleaded and adduced evidence to the effect that she did not commit any offense to warrant the punishment of summary dismissal on her. That the evidence adduced has shown that the guidelines were not followed by the defendant. Hence, the burden of proving that the guidelines were complied with shifts to the defendant. Counsel is of the view that the duty of the claimant is to prove a case on the preponderance of evidence, which was successfully discharged by the claimant, as the evidence elicited from the defense during cross-examination showed that the guidelines were not complied with. Counsel referred to the cases of First Inland Bank PLC and Kraft, OK and Mimico, and Section 137 of the Evidence Act. It is the contention of counsel that it is the contention of the claimant that she was issued only one query before her dismissal instead of 3 queries as provided in the guidelines and exhibit, which is a report of the disciplinary case. It is the contention of the claimant that she was issued only one query before her dismissal instead of 3 queries as provided in the guidelines, exhibit COJ9 and exhibit KHMO3, which is a report of the disciplinary case, is not a minute of any staff meeting or disciplinary committee. Rather, exhibit KHMO3 was made by one Toyin Ajay, who was not called as a witness, and both DW1 and 2 stated during cross-examination that they are not members of a disciplinary committee. Counsel submitted without conceding that if there were any minutes of the committee, if there are any minutes of meeting of the committee, they have not been produced by the defendant, as the documents are not in their favor. Counsel cited the cases of Akbala and Chime and Anike and SPDC. It was also a submission of a counsel that the law is tried that in an employer-employee relationship, the terms and conditions of service govern the relationship and must be strictly followed, citing the case of Texaco Nigeria Limited and Ade Bile, Kende. Learned counsel argued that exhibit KHM2, which is a report of the alleged seizure of a child by the claimant, was not authored by anyone, and it was not the basis for the query for which the claimant was dismissed. Counsel cited the case of FGN and Adigun Akinola, where it was held that document which is neither authored nor signed by any person is incompetent and commands no value. To the counsel, the query issued to the claimant was that she was absent from class, but the claimant explained that she was at the computer lab feeding in results for pupils into the system. That exhibit KHMO2 was made by the defendant in the course of this suit to blackmail the claimant, hence inadmissible, referring to the case of Dolly and Abdullahi and Section 80 sub 3 of the Evidence Act. Counsel further submitted that the claimant was denied fair hearing as enshrined under Section 6 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and cited the case of Anthony and Superior General Lagos State. Are different from report complied by an anonymous person, and the allegations in the exhibit KHM202 are completely different from that which the defendants claim to have used to dismiss the claimant. Hence, the defendants cannot terminate the employment of the claimant on the basis of giving 1 month's notice as contained in exhibit COJ1, but must resort to exhibit KHM06 and exhibit COJ9. Issue 2, counsel urged the court to resolve this issue in favor of the claimant and submitted that the employment of the claimant enjoys statutory flavor. Counsel cited the case of Board of Management, FMC Makodi, and Abakumi, and stated that since the defendant failed to comply with the guidelines in exhibit 6 and 9, then the claimant is entitled to all the relief sought. Counsel also relied on the case of Institute of Health at ABU, Ahmadu Bello University, Hospital Management Board, and ANU. According to counsel, the claimant is therefore entitled to damage in monetary terms upon declaration that the summary dismissal of her employment was a nullity. Counsel cited the case of FMC Ado Ikiti, and Alabi. Council finally urged the court to resolve all the issues in favor of the claimant and enter judgment in her favor. Decision of the courts. I have gone through the pleadings filed by the parties, the evidence adduced, and the exhibit admitted. I've also read the submissions of counsel as well as the issues raised therein. I note that parties have submitted 2 issues each for determination, but I will adopt the second issue for determination submitted by the claimant, which to me will adequately take care of all the issues raised. The issue is as follows, and I quote, whether in circumstances of this case, the claimant is entitled to the reliefs sought. The claimant has asked for 5 main reliefs. Reliefs A and C are for declaration that a purported dismissal by the defendant was in breach of a right to fair hearing and employees' policy handbook and guidelines, hence null and void, that she is still in the employ of the defendant. While reliefs B and D are for orders to set aside the purported summary dismissal and to reinstate her, and the last relief is for general damages. This is a well-established principle of law that the onus of proving the entitlement of the above reliefs rests squarely on the claimant, who is alleging a wrongful or lawful termination of her employment. See the case of Anaja and UBA PLC. Therefore, an employee that is alleging wrongful or lawful termination is required to prove to suspicion of the court that A, he is an employee of the named defendant, which is the employer, B, the terms and conditions of his employment, and C, the manner and by whom he can be removed. See also the case of Emmanuel Iwuchukwu and Engineer David Mwizu, NNPC, and Obu Abdurrahim and Olurutum Toba Oju. The above proposition is in consonance with our jurisprudence in civil cases that the burden of proving the existence or non-existence of a fact is on the party who would fail if no evidence is adduced in his favor. See sections 131, 132, and 133 of the Evidence Act and the case of Aminu and Hassan and Ezenuna and Onyema. Claimant in trying to prove by case standard exhibit COJ7, letter of appointment, COJ9, administrative policy handbook and guidelines. For clarity, paragraph 4 of exhibit COJ7 made reference to exhibit COJ9 and the condition of service between the parties. Claimant has argued that the procedure for disciplinary action as stipulated under section 8.0 of exhibit COJ9 was never complied with before a summary dismissal by the defendant. According to the claimant, the defendant are required to issue 3 queries and 3 warning letters to her before being made to face a disciplinary panel. For clarity, I should reproduce the provisions of section 8 as contained in exhibit COJ9 as follows. And I quote, disciplinary matters. Note, an officer must have received 3 queries, a minimum of 3 warning letters before being considered to face a disciplinary panel. These warnings and query letters must be domiciled in the record of a disciplinary committee and in the personal file of the officer as proof and shall follow this procedure. Number A, firstly, an oral warning with documentation that's in the minutes of the staff meeting. Number 2, secondly, a formal written warning. Thirdly, and finally, a final written warning that clearly states summary dismissal at a repeat occurrence of misconduct. A disciplinary committee shall be inaugurated by the head teacher, and parties accused of any misdemeanor shall be questioned through either oral or written evidence or both before report of finding are forwarded to the head teacher for its immediate action. They shall act in line with the above section and make such recommendation to the school board for approval of such actions, unquote. While section 8.1 spells out the composition of the disciplinary committee, section 8.2 outlines the procedure as follows. Number one, there must be evidence of committal of offense, either verbally or in writing. Number two, issue a written query to the alleged officer. Number C, give fair hearing to the alleged officers. Number D, receive written evidence from witnesses. And number E, make recommendations to the SLB through the head teacher on court. The claimant has stated in her evidence that she was issued only one query, Exhibit 2, and responded to same via Exhibit 8, and that she had never been found wanting on any ground prior to the action under complaint. Neither has she been sanctioned nor warned by the defendant on any misconduct to warrant her summary dismissal in the manner it was done. See paragraph 7, 8, 9, and 15 of her deposition. The defendant have, however, in response maintained that they did not breach the provisions of Exhibit COJ9 in arriving at the verdict against the claimant, and that the claimant had been verbally warned and reprimanded in the past. See paragraphs 11, 14, 15, and 16 of the evidence of DW2. DW1 also stated under cross-examination that the disciplinary committee recommended 1 month suspension against the claimant, and that the procedure for discipline of a staff has to be followed, but the third defendant has to have the final say. It was further stated by DW2 during cross-examination 2 that the claimant was given 3 written warnings and 1 query. But it was stated in another brief by DW2 that the committee only sat on the allegation in the query, and that the claimant was given 3 queries and 3 warning letters before she faced the disciplinary committee. I've carefully examined the provisions of Exhibit COJ9 as regards disciplinary matters vis-a-vis evidence adduced by both parties. The query letter Exhibit 2 dated 19 July 2018 alleged abandonment of duty by the claimant on 17th of July 2018, 18th of July 2018, and 19th of July 2018. And the claimant responded by explaining that she never abandoned her duty, but went to prepare her children's results at the computer lab and to also supervise the children's program as a member. See Exhibit COJ8 dated 19 July 2018. Following Exhibit COJ8, Exhibit COJ3 was issued by the defendant inviting the claimant to appear before a panel of inquiry of the local school board. Thereafter, Exhibit 4 was served on the claimant, summarily dismissing her from the service of the defendant. I observed that besides these happenings, there's nothing before this court showing that the claimant was issued more query letters beyond Exhibit COJ2, nor were there any warning letters served on her for any other misconduct. The claimant, in response to the query, gave explanation as to where she was on a date cited in a query letter. But the defendant sitting as a disciplinary committee did not call any witness or even the class assistant, Patricia, mentioned by the claimant to ascertain the claims thereof, or that the results were actually keyed into the computer. COJ7, letter of appointment, and COJ9, administrative policy and guidelines bind the parties in the instance case, and a law, once parties out of their own free will and volition enter into written agreement, they should be bound to honor and be bound. They should be bound to honor and be bound by the terms of their agreement, and therefore the relationship and subsequent disagreement must be resolved in accordance with their agreement, and the court cannot go outside the terms as agreed upon by the parties. It was telling Ahmed and the CBN that parties are bound by their terms of contract, and the court cannot read into such contract what was not within contemplation of the parties, except where fraud, duress, or mispresentation can be established. It is instructive to add that the terms of contract between the parties are clothed with some degree of sanctity, and if any question should arise with regards to the contract, the terms in any document which constitute the contract are unquestionably the guide to its interpretation. It's also not within the purview of the court to rewrite a contract for the parties. See Minaj Holdings Limited and AMCON. The court, therefore, in determining whether there has been a breach of that contract, are enjoined to confine themselves to the plain words and meaning derived from the document. See Oyamenda and Abdurrahman. It is clear from the evidence and exhibit adduced in this case that there's nothing before this court to show or suggest that 3 different queries and 3 warning letters were given to the claimant before she was asked to face the disciplinary panel, which led to her dismissal. Even though the defendant had contended that the termination of the claimant, of the employment of the claimant, was in accordance with the handbook policy, but I have not been able to see any evidence in support of that contention in the defendant's evidence. The defendants have not strictly complied with Exhibit 9 by affording the claimant the opportunity of receiving 3 queries and 3 warning letters before she was made to face the disciplinary panel. From the foregoing, therefore, I am of the opinion that termination of the claimant's employment on the ground of misconduct without exhausting the available procedures was not in compliance with the administrative policy handbook and guidelines. The claimant has also asked for reinstatement on the basis that her employment was statutory. However, an employment is said to be laced with statutory flavor, where same is created by statute or are regulated by terms and conditions of service. In the case of Council of Enugu, University of Science and Technology, and Uday, it was held thus, and I quote, an employment is said to have statutory flavor when the appointment and termination of such employment is governed by statutory provision. In other words, where the contract of service is governed by the provision of statute or where the conditions of service are contained in regulation derived from statutory provisions, hence such employment is said to enjoy statutory flavor, unquote. See also the case of Shita Bay and the Federal Civil Service Commission, Federal Medical Center, Ado Ekiti, and Kayode. It was said in the case of Shita Bay Supra that the civil service rules of the Federal Republic of Nigeria, that the civil service rules of the Federal Republic, Federal Public Service, which govern conditions of service of the Federal Public Servant, made pursuant to the then 1963 Constitution, have constitutional force, and they invest the public servant over whom they prevail a legal status beyond the ordinary or mere servant and master relationship. However, the fact that an employer is a statutory body does not elevate all its employees with status of employees with statutory protection, or that the conditions of service of its employees must be of a special character, ruling out the relationship of mere servant, mere master and servant relationship. The court must confine itself to the terms of contract of service between the parties, which provide for their rights and obligations. It is also essential to state that the question whether a contract of employment is governed by statute or not depends on the construction of the contract itself or of the relevant statute. See Olorun Toba and Abdurrahim Supra. In the instance case, there's no evidence from the claimant that the defendant are created by any statute or that her condition of service has any statutory force that invests her with any legal status beyond the ordinary or mere master and servant relationship. In other words, there's no evidence that the claimant's contract of service is governed by the provision of any statute or that the condition of service is contained in regulations derived from statute. Rather than from the above, therefore, I cannot find that the employment of the claimant or the defendant was protected by any statute. Hence, the relief for reinstatement cannot be granted, and the dismissal cannot be declared null and void or unlawful, but rather wrongful. The defendant had contended that they can't terminate the appointment of the claimant at any time for no reason when by the claimant's employment letter. Even though Exhibit 4, which is the letter of summary dismissal, contains no reason for the dismissal, but the law is that where an employer terminates an employee's employment without reason, by certain reasons thereafter in his evidence, then he has to justify the reasons so stated. I therefore find it clear from the pleadings of the parties and the evidence proffered that termination of the employment of the claimant was based on her alleged abandonment of duty, but not actually for no reason, where she was merely given 1 month salary in lieu of notice of termination. While it is understandable and a settled principle of law in private employment that an employee cannot be forced on an unwilling employer, and an employer can terminate employee's appointment, but such termination must be done in compliance with the terms and conditions of the contract of employment. And while the termination is wrongful, the employee is entitled to damages for wrongful termination and not reinstatement. See the Supreme Court case of Obanye and UBA, and Garuba and KIC Limited. Flowing from the above, therefore, I find that the case of the claimant succeeds only in part, and I therefore make the following declaration and orders. Number one, a declaration that the purported summary dismissal of the claimant from the employment of the defendant is in breach of the policy handbook and guidelines, and therefore wrongful. Number two, that the letter of summary dismissal dated 10th September 2018 is hereby set aside. Number three, that reliefs C and D are declined and dismissed. Number four, that by virtue of Section 19 of the National Industrial Code Act 2006, and the case of Sahara Energy, the claimant shall be paid the sum of 743,000 naira, meaning a 2 years salary as general damages. Judgment is entered accordingly with no other as to cost.
As the court pleases. We are most
my Lord. We're grateful.
Thank you.
We appreciate my Lord for the indulgence industry, and we are grateful.
Thank you, Mr. Olatunde.
Thank you, my Lord.
I will send the judgment to you. I will ask the DR here to forward it to, the judgment.
Yes, sir.
As a copy.
As the copy.
The hard copy.
Okay.
The hard copies and the soft copies, you find it from our portal.
Okay, the soft copy as copies.
Yes, to be. Thank you so much. Thank you.
If we may exit the meeting now, my Lord. If we may exit the meeting now, my Lord.
You are not wishing my Lord happy weekend. You want to exit?
And it's good to see you again, my Lord.
Thank you so much.
It's good to see you.
Okay.
Thank you.
I wish my Lord a pleasant weekend because he had the job. Thank you, sir.
I'm grateful. Thank you.
Bye bye. My Lord, God continue to keep my Lord with his hard work.
Thank you.
Thank you, sir.
I appreciate that. Thank you.
Thank you, sir.
Okay, thank you.
God's power. God's power. God's time. Oh, it was a good one. They gave us only 755. Whoa. It's church. This. Okay. How you see on? You see on?
Yes, Mr. Sunday Ako, are you around? And
yes, I'm around, my Lord.
Okay.
Yes, my Lord.
Yes, Jen. What is absent, ba?
Yes, my Lord.
Absent, my Lord.
Okay. Sunday Ako.
Yes, my Lord, for the claimant.
Okay. E.N. Tionsha.
Yes, my Lord. For the defendant.
For the defendant. There's
yes.
only one defendant.
Yes, my Lord.
Okay. What about Fire Me
Fayemi is now underemployed engagement.
Okay,
with First Bank, my lord.
Okay.
Yes,
she will need to engage me in future.
As a legal
as a legal representative, whenever they have to with an employer.
She's a legal area manager in Ibadan.
Okay. Wow. That is a big employment.
Yes, my lord.
Because she has been representing them, all along.
Yes, my lord.
Okay. So this is my judgment.
As a complices.
Yes, by a complaint and other accompanying processes dated 17th September 2018 and filed on 16 October 2018, the claimant seeks the following reliefs against the defendants as endorsed in his statement of facts. Number one, the sum of 12,040,939 naira 20 kobo, being total sum of the unpaid balance of the salaries, entitlements, and or allowances owed the claimant by the defendant as per paragraph 13 hereof, plus interest thereon at the rate of 50% from the date of judgment until same is finally liquidated. Or to an order of court directing the defendant to pay to the claimant the sum of 5 million naira only as general damage for breach of contract, financial pains, loss, and untold hardship. Number C, the claimant claims such other consequential and or equitable relief at the court may deem fit to make in the circumstance of this case. On 15 November 2018, the defendant filed his memorandum of appearance and settlement of defense by leave of court granted on the 28th of November 2018. From the pleadings of the claimant, it is about that he was offered employment by the defendant via its Human Capital Management Department, Insource Limited, on 8th October 2010 as a teller officer / service executive, and his employment was confirmed in 2012. And the claimant stated that even though he was working, the defendant never paid him his complete monthly salary as contained in his letter of employment. That he kept complaining to the defendant, and the defendant promised to pay him the balance of his salaries, but never did so even after he resigned in July 2018 following the denial of access to his official email by the defendant. The defendant in her defense stated that the claimant was at all material times a staff of Insource Limited, which is distinct from the Human Capital Management Department of the defendant, and thus was never a staff of the defendant. The defendant also denied all the reliefs of the claimant and stated that there was no contract of employment between it and the claimant, but stated further that while the claimant was out of what was outsourced to it, he absconded his duties after a fraudulent transaction and sent his resignation letter to the defendant via courier. The claimant thereafter filed a reply to the defense of the defendant on 27th November 2018. Trial in this matter commenced on the 6th of March 2019 with the claimant testifying as CW1. He adopted his two sworn statements dated 16 October 2018 and 27 November 2018 and tendered the following documents as exhibits. Exhibit JVA1, JVA2, JBA3, JBA4, JBA5, JBA61 to 618 to 64, 6A1 to 642, JB7, JVA8, JVA9, JVA10, and JVA11. Claimant was cross-examined by counsel to the defendant and closed his case after re-examination. On the 5th of May 2010, the defendant called one Moses Oteku as DW1, who adopted his deposition dated 15 November 2018 and identified exhibits 2, 3, and 11 as the same documents he referred to in his deposition. DW1 was then cross-examined by counsel to the claimant, and in the absence of re-examination, the case of the defendant was closed and the matter was adjourned for adoption of final written addresses. Defendant's final written address is dated 23rd March 2020, but filed on the 13th July 2020 contains 2 issues for determination as follows. Number 1, whether the claimant has proved the existence of a contract of employment between himself and the defendant, which the defendant is in breach of. Number 2, whether the claimant is entitled to any claim in damages against the defendant. Issue 1, the other counsel for the defendant in arguing the above issue submitted that the claimant has failed to establish the existence of a contract of employment between himself and the defendant. That it is tried that he who asserts must prove, and a plaintiff who must succeed on the strength of his own case. Counsel cited Section 131 of Evidence Act and the case of Bank of the North and Onyo. Counsel also submitted by Exhibit 2, 3, and 11. The claimant has employment relationship with Insources Limited, and Insources Limited is a different company from the defendant. That an agreement in writing is a document that speaks for itself, and no extrinsic evidence will be admissible. Counsel cited the case of Fagi and Tuku, and Bolade David Oladapo and Stanbic IBTC Limited. So the first submission of counsel that the defendant not being a party to a contract of employment with the claimant cannot be bound by the terms of contract. Counsel in explaining what privilege of contract entails cited the cases of CCD Limited and Onwokocha, Akanwa, and Obaga. Counsel contended that the decision of this court in Donatus, Onuma Lobby, and NDIC, wherein the principle of co-employer and triangular employment was applied, cannot apply in the instance because the fact of this case differs from the case referred to. Counsel further contended that failure of the claimant to join Insources Limited as a party and to also lead credible evidence to show that the Insources Limited is an agent of the defendant is fatal to the case of the claimant. Therefore, where an authorized agent makes a contract in his name without disclosing that he is acting on behalf of another, then he can sue and be sued in his own name. Such in the case of Okafor and Ezenwa. According to the defendant, the claimant has failed to establish any privilege of contract between him and the defendant, and therefore not entitled to the reliefs sought. Issue number 2, Learned Counsel on issue number 2 maintains that the claimant is not entitled to any damages against the defendant, as he has failed to substantiate what he claimed under paragraph 15A and B of his statement of facts. That by his offer of employment, the claimant was entitled to 58,600 as his monthly salary and not 145,000 naira as alleged by him. That he has not placed before this court his pay slip to show his net pay after deduction, or that there was upward review of his salaries, which he claimed he could not print because he was denied access by the defendant. Counsel argued that the claimant did not work from October 2017 to August 2017, hence he cannot be paid, as Exhibit 8 dated November 2017 confirmed that the claimant reported to work last in October 2017, as his evidence from work led to Abola Ademi to reach out to his guarantors. The claimant has not proved his claims for terminal benefits and ex gratia, but rather he owes the defendant for resigning without giving it 1 month notice. Just equally, the argument of counsel that special damage requires strictest proof and cited the case of Achinkube and Eulu Holdings. On general damage, counsel submitted that the claimant has been unable to prove any wrongdoing against him by the defendant. Thus, he cannot be entitled to any general damages. Counsel rely on the authority of GFK Investment Limited and Nigeria Yearly Communication PLC and urged the court to dismiss the claims of the claimant. Claimant submission. The final written address of the claimant dated 6th October 2020 but filed on the 16th October 2020 contains two issues for termination to it. Number one, whether the claimant has established privity of contract between the claimant and the defendant, and whether in the circumstances of this case, the claimant is a staff of the defendant and therefore entitled to sue her for damages as per his claims. Number two, whether the claimant has proved his case against the defendant to be entitled to the payment of the balance of his initial agreed salaries, the balance of subsequently unpaid review salaries, and the terminal benefits withheld by the defendant. Issue one, counsel and counsel for the claimant submitted that by the evidence presented, it is clear that the claimant was a staff of the defendant. That by Exhibit 1 and 11 tendered by the claimant has shown that he was employed by the defendant on 8th October 2010 before Insourcing Limited came on board as agent / extension of the defendant Human Capital Management Department. And since Exhibit 1 and 11 were admitted without any objection from the defendant and also corroborated the evidence given by the claimant, the court is to attach the requisite weight to them for a just determination of this suit. Counsel cited sections 33, 34, and 36 of the Evidence Act and the case of Hallmark Contractors Limited and Gomwork. Counsel also submitted that the defendant acceded to the exhibit before the court was just to deny liability by hiding behind the technicality of disowning the claimant. Now, this does not stop the fact that the contract between the claimant and the defendant is binding and enforceable. As DW1 admitted that Insourcing is an agent of the defendant. Counsel rely on the authority of CBN and Interstellar Communication. That facts admitted need no further proof. Counsel contended that upon employment, the claimant was issued staff identity card, Exhibit 4, and employment handbook, Exhibit 5, by the defendant, and he worked at the banking hall of the defendant as admitted by the evidence of DW1 and further corroborated by Exhibit 6A1, claimant's payslip. Counsel also contended that the basic incident of employer-employee relationship, the payment of salaries and allowances as evidenced by Exhibit 6, which clearly showed that the claimant was an employee of the defendant. Counsel cited the case of Mobile Producing Nigerian Unlimited and Udo Tom Udo. The counsel argued that the evidence laid by the claimant that he was at all material times an employee of the defendant has not been shaken or contradicted, and the court thus can act on it. Counsel rely on the authority of Salami and Ajadi. It was also argued that the defendant never objected to the responsibility of Exhibit 1 and 11, and this exhibit present the claimant as its employee. Hence, it is deemed as admission under Section 20, 21, and 24 of the Evidence Act. Counsel also cited the case of Ogu, Nuju, and Chioboka, and Chief CO Ojuku and Dr. Edwin, that the defendant is stopped by Section 69 of the Evidence Act from denying its employment relationship with the claimant, citing also the case of Ali and Alessin Loye. They submitted that the general rule of privity of contract has an exception, one of which is any contract entered into by an agent on behalf of a principal, and also while the principal is disclosed, it is the principal that should be sued for act of the agent. Relying on the case of Conan and John. It was also submitted that Exhibit 1, 2, 3, and 11 were issued by Insourcing Limited for and on behalf of the defendant, and a perusal of this exhibit, especially Exhibit 11, clearly shows that Insourcing Limited was acting as an agent of the defendant. That the exhibits have corroborated the evidence of the claimant. Counsel argued that the claimant was paid salaries by the defendant, hence the claimant cannot be said to be an independent contractor. Citing the case of Flash Fixed Oils Limited and Akatuba, that the law remains established that services and wages are twin pillars of a contract of employment. Counsel cited the case of Mobile Producing or Limited and Odotom. Counsel urged the court to resolve this issue in favor of the claimant, as evidence abound that the claimant was the employee of the defendant. Issue 2, counsel argued that Exhibits 1 and 11 contain the monthly salary and allowances of the claimant, and some having been admitted without objection from the defendant can be relied upon in resolving this issue. So the second issue should be answered in the affirmative, that the claimant has proved that he is entitled to the relief sought in his pleadings. It was also argued that the evidence adduced by the claimant as regards the payment of his salaries and allowances and other entitlements were not challenged during cross-examination. Counsel contended that Section 167 of the Evidence Act be invoked against the defendant for refusing to produce in court documents mentioned in paragraph 3, 4, 9, 10, and 14 of the Statement of Fact, even upon service of notice to produce. Counsel also relied on the cases of Okereke and Omani. On the failure of the defendant to cross-examine the claimant, counsel cited the cases of Akinwumi and Idowu. Finally, counsel urged the court to hold that claimant has proved his case to be entitled to the grant of all the relief sought in paragraph 15 of the Statement of Fact. I've carefully considered the procedures filed by the parties, their evidence and exhibit admitted, as well as the respective submission of counsel. In the final written addresses, both parties submitted 2 issues each for determination. But the issue I find most suitable in determining this matter is whether the claimant has proved his case against the defendant to be entitled to the relief sought. The claimant in his principal relief has asked for the sum of 12,040,939 naira 20 kobo, being a total sum of his balance of salaries, entitlement, and all allowances owed him by the defendant. In proof of his main relief and, of course, the other reliefs, the claimant tendered a total of 11 exhibits and contended that he worked for the defendant from October 2010, but was never paid his full salary, as stated in his letter of employment up to October 2017, when he was denied access to the banking portal to enable him discharge his duties, as a result of which he resigned. Under our civil jurisprudence, the body lies with the claimant to adduce cogent and credible evidence in support of his claims before the court. By the provisions of Section 131, 132, and 133 of the Evidence Act, the person who asserted affirmative had the honors of proof. See also the case of Unwavu and Okwei. The defendant in his contention stated that the claimant has failed to establish the existence of a contract of employment between himself and the defendant. In that case, it is imperative to carefully look at Exhibit 1 and 2. Exhibit 1 is the application for employment written by the claimant, which was addressed to the personnel manager of the defendant through the manager Insourcing Limited. Meanwhile, Exhibit 2 is the offer of employment given by Insourcing Limited to the claimant. It is obvious from Exhibit 1 that the defendant was the one who employed the claimant via Insourcing Limited, while Exhibit 2, staff identity card issued by the defendant, had the same staff number as cited by Insourcing Limited in Exhibit 2, offer of employment. Exhibit 6A1 to 42 also clearly shows that the defendant was the one paying the monthly salaries of the claimant from October 2010 when he was employed to October 2017. Equally, DW1 admitted during cross-examination on 5th March 2020 that Insourcing Limited is an agent of the defendant. The law is elementary that the first admitted requires no further facts admitted require no further proof. See the case of Ashapa Foods Factory Limited and Aranye Limited. It has been held by the court in a plethora of cases that an agent acting on behalf of a disclosed principal incurs no liability because such acts of the agent are acts of the disclosed principal. See the case of Alhaji Muhammad Ibrahim and Yakubu Musa. In other words, it is fairly settled that an agent of a disclosed principal suffers no liability for such acts which bind the principal. See the case of Amar Dume and Ibok. Similarly, it is a general principle of law that a contract made by an agent acting within the scope of his authority and for a disclosed principal is a law the contract of the disclosed principal, and the principal is the proper party to sue. See Cullen and Unijos. I have also carefully perused Exhibit 11. It's an agreement entered between Insourcing Limited and the claimant on the 9th of August 2012, and it was signed by the claimant and one Pundip Pun Iyodi as branch manager of the unit of the defendant, Makodi Modern Market. I observed from the exhibit that the address of the claimant is the defendant office in Makodi. I observed also that all the clauses in Exhibit 11 of this exhibit refer to a bank. And the question I will ask is, if the claimant was not working for the defendant, is Insourcing Limited a bank?
It's called places.
I need to further refer to clause 7 of the same exhibit 11, which reads thus, and I quote, that the bank will, during the term the employee shall remain in their employment, hereunder pay or cost to be paid to him by equal monthly payment on the last of every month, a salary at the rate of 148,000 naira a year, unquote. All what the above means is that the act of the defendant and Insourcing Limited regarding employment of the claimant will lead to no other conclusion than that Insourcing Limited recruited the claimant to work for the defendant. Hence, Insourcing Limited is an agent of the defendant, and I so hold.
As the court places.
Turning to the contention of the claimant as regards his monthly salaries. He argued that he was supposed to be earning a monthly salary of 145,000 naira, but the defendant was paying him 55,000 naira. And that even when the defendant reviewed his salary upward to 303,000 naira, he was still being paid a lesser sum of 85,000 naira. I carefully studied Exhibit 6, which are the settlement of account, Exhibit 2, offer of employment, and Exhibit 11, agreement between the parties. Paragraph 2 of Exhibit 2 reads, and I quote, your appointment is on a commencing basic salary of 87,000 naira per annum. The phrase per annum here means annually as opposed to monthly. Since per annum means yearly or annually, the amount to be paid as salary to the claimant by the defendant is to be divided by 12 months in order to get the monthly salary of the claimant. Therefore, when the basic salary, which was 7,000 naira, is divided by 12 months, you will get a figure of 7,320 naira. And when each of the allowances contained in Exhibit 2 are divided by 12 months, the monthly salary of the claimant together with the basic salary become 64,000 naira, and not 87,000 naira as claimed per month. The figure in paragraph 7 of Exhibit 11 was also to be paid annually. The figure of 145,000 naira as contained in Exhibit 11, which was issued after the confirmation of the claimant, upgraded his annual basic salary from 87,000 naira to 145,000 naira. When this new figure is divided by 12, it gives a figure of 12,126,000 naira per month. And when added to the other fringe benefit in Exhibit 2, total amount payable to the claimant as monthly salary will be 69,805 naira. This figures as
I didn't hear anything. Sorry, my lord, I got lost out. Can't even hear anything.
Can you hear me?
I can't even hear.
But can you hear me?
Yeah, I can hear you now.
But I can't hear my lord.
Yeah, I can't hear. I even got lost out. Somebody was busy calling me and it scattered. It's like my lord is out, sir. I can't even see him.
He's out. He's not on. He's not. He has to come in. Okay, he has come in. Sorry, my lord. I think there was interception with the.
Yes. There's network issue, but it's now restored. Okay. So therefore, the claims for payment of unpaid salaries is for liquidated sums, thus a special claim which by law must be specifically pleaded and proved with certainty to warrant a grant of same. In the case of Union Bank of Nigeria PLC and Alhaji Adams, Supreme Court has said, and I quote, the law is tried that unless pleaded and strictly proved, the court is not obliged to make any awards in that regard for special damages. See also the case of Osuji and Isiocha, NNPC and Clipto. From the foregoing, therefore, I cannot find the basis for the grant of this relief for unpaid / balance of salaries. On the claim for general damages of 5 million naira, in the case of Afolabi and Ola, it was shown that general damages are only awarded where there is a breach. It follows, therefore, a claimant who has not established a breach of contract cannot be entitled to general damages. On the whole, and for all the reasons given above, it is clear that the claimant has not, by any evidence presented, established that he was being underpaid by the defendant or that he was entitled to any payment of resignation of his employment. Consequent upon the above, therefore, it is my respectful opinion that the evidence of the claimant has not discharged the honors operandi placed on him for the grant of all the reliefs sought. The entire suit filed by the claimant hereby fails and is accordingly dismissed.
As the court pleases.
Yes.
We are much grateful, my lord. We appreciate the courts industry.
And it seems you're happy.
Very happy, my lord. Thank you, my lord.
Thank you, my lord.
Thank you, Mr. Sunday. Thank you so much. That's the litigation. So there has to be a winner and a loser.
That's true.
Yes, that's right. I'm grateful, my lord.
Thank you. So, Mr. Sunday and
Tionsha.
That will be all for. Please, my regards to all the lawyers in Macaulay.
Oh, thank you very much, my lord. They will hear you.
Thank you, my lord. Thank you, my lord.
Good
Thank you, my God, everybody.
Yes, sir. Thank you.
And I wish you a very good afternoon and happy weekend in advance.
Thank you, my lord. I wish you the very same.
Thank you. Bye-bye. Thank you.
Weekend, my lord. Wish you, my lord.
Thank you, Mr. Sunday. I'm grateful. Bye-bye.
This person, let us disturb him with call. Don't know how to do this.